Welcome to another episode of the Unprofessional Parenting Podcast. I'm Matt.
And I'm Lainey.
And we have a very special guest with us on this episode. Lainey, would you like to introduce our guest?
Sure. Yeah, this is our good friend today. We have Aaron Hubbard, Your Honor, Family Court Judge.
Yes.
Today on our episode, we're going to be talking about the legal system and how foster parents can relate to the legal system. And then a little bit about what it's like to be a judge and the point of view of a judge through the process of a child welfare case.
Can't wait. Let's get into it. Welcome to Unprofessional Parenting. We're your hosts, Matt and Lainey.
I'm Lainey, a licensed clinical social worker with over a decade of experience working in child welfare.
And I'm Matt, with more than 10 years working in church ministry. And together, we're foster and adoptive parents who know firsthand that parenting is anything but perfect.
We're here to laugh, learn, and share the real side of raising foster and adoptive kids. Parenting isn't about being perfect, it's about showing up even when you feel completely unprofessional at it.
So let's get into today's conversation. Like we mentioned earlier, we have our very good friend here, Judge Aaron Hubbard. We are excited to have you on the podcast today. How are you feeling?
Good. Thank you for having me.
Yeah, no problem. No problem. We're honored to have you here, Your Honor. We wanted to have you on the podcast today to answer a couple questions from the court perspective of what happens in a foster case, because we are foster parents and we know foster parents, and we have had experience with the court system in the past, some good, some bad, some that have left us feeling some type of way about the courts and judges involved and things of that nature. But we wanted to have you on to share your perspective of what it's like in the courtroom, what you have to deal with, and how maybe we can bridge the gap between foster care and the court system and what that looks like for foster parents. But can you just tell us a little bit about yourself, kind of tell us what you do, tell us how you got into law and stuff like that?
Yeah, so I the first stint was as a prosecutor out of law school. After I passed the bar, I became a prosecutor. So I was prosecuting the, quote, bad guys, the criminal cases.
Yeah.
Nice.
So in that, I did that for about 15 years before getting appointed by Governor DeSantis to become a judge. I've been on the bench now for about 3.5 years. So I did a little bit of a stint in what we call injunctions. So there's some dynamics of family law, issues related to the child and contact with the child between the parents. Mm-hmm. And then recently I've moved over into family law, handling cases of divorce, child custody, paternity, and a little bit of adoptions and things like that. So
that's great. What made you want to get into law as a profession?
So when I became a lawyer, I always knew I wanted to be a lawyer. My parents always told me I was good at arguing. Yeah, and I was hard-headed and always stood my ground. So, but I was drawn to the criminal side of things. I wanted to be a prosecutor. I wanted to work for the government and wanted to, ensure that people that were doing bad things, were punished, and and also helping victims in that. And in that, I was just kind of drawn to, I've always kind of been drawn to the children. I have 4 of my own, so I've always been interested in helping protect children and things like that. I did 5 years as a prosecutor, prosecuting child abuse and those kind of cases.
Wow.
So you've seen some stuff.
Yeah. So this has been good for me, over the last couple of years, still dealing with, children and families and, trying to help in that.
Yeah.
Nice.
And not to mention, my wife has been trying to get your wife and you to be foster parents for the past 3 years.
Yeah, we have 4, and right? She would have had 10, but we stopped at 4. But,
exactly. Yeah. That's good. Well, we have some questions for you, Lainey. You want to take
so just kind of start by explaining. We want to know, what is the role of a judge in these cases, in family court cases, dependency cases, because we also want to dive into what the role of a foster parent is, but I think we're all curious, what is a judge supposed to be doing on these cases?
Good. Well, so I guess I'll start with kind of in any case as a judge, you're the neutral party. You are the referee, calling balls and strikes. You're supposed to be the neutral arbitrator. You're not supposed to be prejudice towards one side or the other. So that's kind of always the starting point, is that you're this neutral arbitrator. You're kind of, like I said, the best analogy is like a referee. You're kind of calling, the balls and strikes, and you're kind of ultimately sometimes coming to the final say or the final resolution in what you believe is appropriate. But so that's kind of the starting point. Now, family law and dependency is a little bit different because you're also becoming more of a problem solver. So in this aspect, as a judge in family law, you are actually encouraged to kind of help mediate, to kind of help problem solve, especially when it comes to families and coming up with situations where, maybe creating a better environment for the child, or, who the child should spend more time with, if they should spend any time at all with the parents. So that's what I really like about family law too. It's different from, say a judge presiding over criminal cases where they're just, simply just sitting back and making rulings and allowing the parties to do their thing. So
figured out on that sense. Yeah. What you mentioned, being a neutral party, kind of the referee, right? How hard is it to step into a courtroom and remain that neutral party? Because I know from myself, I'm an emotional person. And so like I could get swayed either way at any time. Riding the fence is a tough thing. So for you, how do you remain neutral in those situations?
It's a good question. I mean,
you have to, first of all.
Yeah, that's really what it comes down to, is you have to. You cannot, base your judgments on emotions. There's plenty of areas in the law where it's discussed. One thing I always comes to mind, and I remind myself, like in criminal cases, when you're instructing a jury, one of the last things you tell them is, that you shouldn't base your verdict on sympathy, or whether you like one side or the other, or basically telling them put aside your emotions.
Right.
So it's really the starting point. I mean, you have to do that. We can't base judgments on emotions, but we're human. So of course, we get emotional, but we kind of, sometimes have to hide it, or you go back in your chambers and, let it all out there. But we have to remain neutral. It's really what maintains consistency in our justice system.
I want to touch on that, because I think a misconception that a lot of foster parents have when we go into court, we are full of emotion because we have this child or children every day. There's emotions involved every second of every day in our homes, in our family life. And it's really easy to walk into a court hearing, feeling some type of way, especially about biological parents, and the frustrations or anger or negative feelings that foster parents can carry towards biological parents for being the reason that all of us are in this situation to begin with. So I know we have felt this way. We've talked to people who have felt this way, who walk out of a court hearing like so frustrated that the judge wasn't angrier at the biological parent for the situation that was going on. So I don't know. I mean, I
was going to say, I even think walking into it, the emotion walking into, the nerves walking into it as a foster parent, that maybe we shouldn't have, and maybe we should let, trust the legal process, and obviously the Lord in all situations, that he's sovereign over all things and all decisions. But even walking into the courtroom, I feel like I've been so nervous before.
Oh yeah.
I've been so, and I've heard bits and pieces of the story of this child that's in my home, and it creates this kind of like anger within me to be like, we need to stick it to these people, right?
Yeah.
So I'm sorry, I didn't mean to cut you off there, but like.
No, that makes sense. Yeah.
Right. So what is the question there?
Well, the question is like, obviously in our logical minds we can say a judge can't come across the bench and like throw a book at these people, right? But what is the perspective of a judge in that situation, and what should a foster parent's expectations of a judge's response in angering situations be?
Yeah, that's a great question. I mean, I think the starting point is that they need to understand that, we are taught and we are told constantly that we are not to, rule based on our emotions, and we can't let that show in court. Because, when we rule based on emotions in any decision in life, when you're emotional, we make rash decisions, we make quick decisions, 100%. We don't think about things, clearly, because our mind is clouded with this emotion. So one of the things that I think it would be good for foster families to understand, and for any people to understand, is sometimes we just don't know all the information, and that's a good thing. And I think sometimes people have this misconception, that we should know everything about the case, meaning, we don't have access to police reports. We don't have access, to things unless they're filed or brought before the court.
Right.
So sometimes when we're making rulings, we're trying to gather as much information, not that we're not wanting to know everything, because a lot of times I'm listening and there's more I want to know, but I can ask questions and I can dig a little bit, but you have to let the parties kind of do their job in presenting. So that's why one thing that I think, and we'll probably talk more about it, is important for foster families is to provide information, to not be scared, to provide information, whether maybe it not be directly to the judge, but maybe to the guardian ad litem, or maybe to, the case manager, and to not feel like you're not allowed to present information. It may just not be directly to the judge.
Right.
But, so sometimes the emotional thing, like we don't know the case like you do. Like we don't know the everyday workings of the kid at home and how he's acting and things like that. So sometimes, we just don't have that much emotion because we don't know the case like a foster family does. We don't see it every day and live it. So I think it's important for them to understand, it's not that we're just cold and, and just not humane.
Just like heartless.
Yeah, it's I don't know the case like you do. I don't know the case like the case manager. And I think that's a good thing sometimes because, again, if we knew every little detail and we lived it out every day, then it would be almost impossible for us to make a neutral decision.
Exactly. So we've done a couple things in the past when we've had foster cases and gone before court. You keep extensive logs on almost everything in our home when it comes to the foster kid interactions with parents, with biological parents, and visits and visitation and things of that nature. And we've been able to submit those things, and it wasn't directly to the judge. It was through those parties like the guardian ad litem and caseworker and things of that nature. But it gave us a chance for our voice to be kind of heard, and the everyday hours that we spend with these children and hearing their stories and seeing their emotions and behaviors and things like that, it gave us a chance to kind of enter that into the court in a certain way, kind of give those emotions some backing, if you will. So what are some strategies you've worked off in the past?
Yeah, so I think, a little rabbit trail here, but I think foster parents keeping rigorous documentation is really important.
100%.
Like you just said, judges don't know every single piece of everything that's going on, and you definitely don't know unless the parties submit those details to you. And then sometimes, from the foster parent's perspective, sometimes the parties aren't submitting those details because there are so many details to consider.
We get a lot of summaries.
I mean, you're getting summaries. You're not getting full logs and details of stuff. These case managers are super overworked. They've got 100 kids that they're dealing with, right? So there's just so many variables here. So you've got a case manager that has 50 kids versus us as foster parents that just have one kid. So I would, in our experience, I have kept, visitation was really like the big thing I would keep records of, like when visits happened, if they were canceled, why they were canceled, what our children kind of did and reacted after those visits. And it was super, super helpful. And I was able to submit it through our assistant state attorney, who then submitted it to the court. But I'm curious, just on a general basis, how much weight does a prospective how much weight does a perspective of a foster parent carry on these cases? So kind of talking about, what is the role of a foster parent? Like, are they a party to the case? Does their opinion matter? And like, how can they tell the judge things that they think is important?
Yeah. So that's, so a foster parent is what we call a participant. So by statute, they're under the definition of a participant to a case. They're not a party, so they're not entitled to necessarily be heard because they're not an actual party to the case.
That's so important.
But they are labeled as a participant. They do have some rights. They're right. The biggest thing is they have a right to be notified of the hearings.
Yeah.
So foster parents should make sure that they're being notified. I think it's 72 hours at least that you have to be notified of a hearing,
Okay.
Which gives you the right to be present. But that's kind of where it stops. And so that's where the foster parents have to understand you're a participant, just like, most courtrooms are open to the public.
Yeah.
So you're welcome to come and sit. But it doesn't mean that you have the right to, come up and say something. But there are other avenues to get your voice heard. And like you said, the assistant state attorney in a dependency case, they're the party that's presenting everything to the court, the case manager, the guardian ad litem. So back to your thing, I think it's critical for foster parents to keep logs, keep notes, do what they can to try to document everything. Because if it becomes a question of, somebody's challenging it, then they have that. But the foster parents, I'm sure it's frustrating for them because you just have to sit back and be labeled this, participant while you're doing most of the legwork, trying to help these kids and trying to, get them stable and take them places and all that stuff. But at the end of the day, the statute says you're a participant to the hearing.
Yeah.
Which is basically just like an observer, really.
Yeah. Wow.
So is it fair to say that like a judge doesn't even really have to take into consideration our opinions or concerns or anything like that?
Yeah, that's a fair statement. There's nothing in the law that says it's binding on them, or that they even have to be presented. It's up to your state attorney or it's up to the guardian ad litem or your case manager to bring it up. So
wow. Yeah. I think that's the tension point right there, is the participant in the court hearing. You're not like a part of it.
Right, but I think it's also important to point out here that like that is in the law. That's written into the law. That's not a judge saying I don't care about your opinion.
100%.
That's not.
It's by statute.
Right. Yeah. So you are there to carry out the law and make sure the law has integrity, and it's not like a game of I choose you over you, or I'm in favor.
Yeah, or you're not important enough, or whatever.
Right.
But that's the tension point. Is I feel like, even just from my perspective, being a foster parent, I feel like I have wanted to be the investigator, wanted to be the prosecutor, wanted to be the judge in the case, because I've seen bits and pieces, I've heard bits and pieces, and I'm like, cut and dry. Let's get moving with this, right? And so that brings about this like anger and frustration along with it that I think that foster parents are continuously wrestling with when they enter the courtrooms. Like, understanding your role is such an important thing. Like and we've talked about this for the past few weeks on this podcast. It's like understanding your role as a foster parent. You are there to love and to provide safety and security for the children who are in your care. That is your role. That is your role.
Yeah.
So understanding your role is such an important thing.
And setting your expectations too, based on that,
Exactly.
knowing that going into this, you're just labeled as a participant by law, not that the judge doesn't want to hear from you, but there is independency in family law. Like I said, the judge can be a problem solver. You're encouraged to solve the issues in the best interest of the child or the family as a whole. So, a judge could get curious enough where they say, hey, I want to hear from, the foster parents, but that has to be funneled through the right party, your assistant state attorney, or your guardian ad litem or case manager.
Right.
So, I would encourage foster parents that, the old squeaky wheel gets the grease, right? If you have a situation that you think really should be brought up to the court, really try to get that funneled through the appropriate party. But again, understand you can't just, stand up in the back of the courtroom waving your hand and,
I object.
Say, I object or I want to be heard from, because you probably might get thrown out of the courtroom. You never know. But no, so that would be frustrating.
Yeah.
I can see that
Well,
frustration.
you mentioned best interest of the child. So I want to talk about that for a second.
Yeah.
So what does that mean when a judge is looking for the best interest of the child? And the context here is we've heard it 100 times from other foster parents walking out of a court after a judge has made certain decisions on the case, and they're going, that is not in the best interest of this child in any way. So from a foster parent's perspective, they're saying the judge is not working in the best interest of their child, the child. So from the judge's perspective, what does that mean, and what is a judge looking for as best interest?
So to me, the best interest of the child, you almost have to see things through the eyes of the child, really. Like, because sometimes there's situations where, you know, a young child, for example, you know, a 4 or 5 year old child, like they don't know much, right?
Right.
And they're worried about food and, you know, playtime and that. So sometimes you have to see it through their eyes. Like, so maybe as parents or as foster parents or as adults, we know, you know, it might not be a good idea for them to be spending time with dad, but maybe that can be done in a supervised setting or, you know, something like that. So you kind of, when you look at the best interest of the child and see it through their eyes, like they don't know any better as far as who this person is, dad, you know, and the things that he's done. So maybe it is in their best interest, you know, emotionally or developmentally for them to be able to know this person and to see this person. So then you start thinking about, well, how do I gauge, you know, the safety for the child? And so there's a lot that goes into it, but again, we're supposed to be looking at, you know, what is in the best interest of that child, safety wise, you know, emotional, you know, developmental issues, things like that. You know, sometimes it's medical. But I think in dependency, it's more, seems to be geared more towards safety. I think, whereas family law, it's more of the just kind of long-term, you know, how is this kid going to develop emotionally if he doesn't have, you know, enough time with dad or mom or so. But, you know, again, that standard is across the board. It always has to be in the best interest of the child.
Yeah. Well, you talk about best interest of the child. There are times, I think, when foster parents also feel, you know, they have the kid in their home for days, months, sometimes even years. Foster families, we know foster families who had an open case for years, multiple years. And so we're sitting there and we're like, you know, when is this going to have some finality to it? Like what is taking so long? This should be something that we ruled upon, or something that, you know, happened a long time ago. A decision should have been made. But it feels like it just keeps getting drawn out longer and longer and longer. So can you give us a little bit of perspective, maybe even from your side of things, of like, why is there so much space in between hearings? Why do the court process take a long time? Why, when we have one hearing, do we schedule a hearing out for 9 months from now? I have opening in, you know, April of 2028. So we're gonna do that. And we're like, wait a second, this needs to be decided now. Like, this is a dire emergency. Like, we need answers like now. Why is there so much time built into those things?
So I mean, I think it's what we're trying to do as judges, you know, when you're looking at the family dynamic, like we're trying to create stability for the child. And one of the other things that you'll see in statutes and the law, it talks about permanency. Like, you know, so as we're making these decisions, you know, it's supposed to establish stability and permanency for the child. So we're supposed to be looking at solutions that will, you know, create long-term things for this child. So you don't want to rush that. I mean, that's part of the issue, is you want to make sure that you have as much information to do that. So sometimes the delays are information gathering, because again, going back to, we don't always have all the information, but, you know, sometimes as a judge, you can tell, you know, there's something I'm missing here. So maybe if we, you know, put this in place and maybe set it off 3 or 4 months, maybe I'll get those answers. Or, you know, let's see how the kid does over the next 3 or 4 months. So, you know, you don't want to rush these decisions. Some of them, you know, you can, because they're just dire emergency. There's physical violence, sexual violence, you know, some are very, you know, emergency situations.
Like egregious abuse.
But, you know, everybody's definition of emergency is different.
Yes,
you know,
true.
we get a lot of, in family law, we get a lot of emergency filings. You know, this is an emergency, and it's not an emergency. It's something maybe expedited, or sometimes it's just not an emergency at all. So, And that's another thing. Like, families have to understand that going into this. Like, what does the law say an emergency, a true emergency is? And it's usually physical violence, sexual violence, neglect, extreme neglect, things like that. You know.
But it's not like mom needs to go to parenting classes.
Yeah. No.
And just learn better parenting and coping skills. Like, that's probably not an emergency.
Or his dad's house, doesn't have an extra bedroom and the kid's sleeping on the couch. That's not an emergency. It's may not be good.
It's inconvenient.
Yeah, inconvenient, or maybe it's not the best environment per se, but so in different cases are going to require different time frames. Like I said, there's going to be cases where right away you just know this needs to be dealt with quickly. But then I think judges see cases where there's maybe some long term, or maybe some 3 or 4 or 5 months, where we can see how the kid develops and come back and check on it. That's more appropriate.
Yeah, I think in a lot of those situations where it is information gathering or just a wait and see type of situation, foster parents tend to feel like that is the court just giving biological parents another chance.
Third,
they got another chance. They're still not doing the right thing, and they got another chance. Like, when are we going to end this so that the kid can have permanency? And I want to set up a little scenario that I think probably every foster parent who's done this for any length of time has experienced. And it's when you have a biological parent who is just very obviously not doing the right thing. Like, they're not following their case plan. They're still using, or they're still in that abusive relationship that they're not supposed to be in. They're like, whatever.
Being arrested.
Yeah. Like they're still in trouble with the law. Like, all these things, whatever the abuse was that brought that child into care, the foster parents, who can see kind of behind the scenes, can see that parent is still very much engaged in that lifestyle, right? And then we come to court, and everyone's wanting to put their best foot forward. Like, no biological parent is walking into court going, "Yes, Your Honor, like, I just used yesterday." Like, no one's saying that, right? They're trying to put their best foot forward. We as foster parents feel like, I can see right through that. They're lying, or they're manipulating the situation. And then the judge makes a decision of, okay, you are in partial compliance, and we're going to give you another 6 months to keep working on this. Do your best to engage in those parenting classes. Do your best to, take more drug screens or whatever. Like, whatever it is, it feels like there is just so much grace and mercy being given in a situation that foster parents often feel like is too much. Like, when do we stop with the grace and mercy and just give this child permanency? So I don't know. I'm not really sure what the question is on that, other than just like, can you respond to that type of situation from a judge's perspective?
No, I get what you're saying. And I think it comes down to, well, one of the things that, again, foster families should understand is there are some like precedents. There's some presumptions. Like in family law, it's, when it comes to child custody, there's a presumption that it should be 50-50. So that's kind of our starting point. So
what does that mean, 50-50?
Meaning like that it's presumed, there's a presumption that mom and dad should have 50-50 split time with the child.
Gotcha.
Yeah. So we're working now, you have to look at the situation and work one way or the other. So, but we have this presumption that says 50-50. Well, if dad is physically abusing the kid or something, then that starts to get you away from that. But when it comes to dependency, there is a presumption that it's in the best interest of the child to remain with their mom and dad, their biological parents. So as a judge, when you're making your...
Say it louder for the people in the back.
That is. And
you were trying to figure out what the question was. I kind of wanted to set it up as that. Like, what is the best thing for the child? The perfect solution, walking out of the courtroom and the case being closed. What would be the
ideal
the ideal positive from it?
Well, I mean, the ideal would be that mom and dad would turn their life around
100%.
and be parents. And so, but as a judge, you have to push towards that. And that's why you see all this grace, and second, third, fourth, fifth chances, because, the judge's ultimate goal is to get them back into that home and to create a safe and stable environment for them, because it's presumed that it's in the child's best interest moving forward that they be with their biological mom and dad, because then it avoids down the road, them, well, where's my dad? Where's my mom?
Right.
So you always have that in the back of your mind, even in family law and divorce cases and child custody. We have to say ultimately the best solution would be if everybody just did what they're supposed to. But you have to kind of operate like that. So as a judge, you can't just sit there and go, well, dad got arrested, for something, and he's not doing what he's supposed to do, and so just boom,
just terminate his rights.
Terminate his rights, and this foster family is great, and they can provide for this kid. So you have to make sure that are trying to give these chances to the person to try to get to that ultimate goal, because that is the goal. The goal is stability for the child, but as a judge, you would feel the best if you could walk away from a situation and say, hey, we turned mom's life around. She's now parenting. She's being a good mom. She's doing what she's supposed to. Like, that's the best situation. Second best situation is, we got him into a good family that can provide for him.
But that's not the goal going in.
No, it's not. It's not. The goal is not to just find the best, the family that can provide and provide nice things and send them to the right schools and things like that. And I feel like sometimes foster parents get frustrated because they go, look at all these resources I have. I can provide a better life for this kid, but that's not the standard.
So good. The whole time you've been talking here, I've been thinking about a conversation I had with an attorney in the dependency space. And she was saying the same exact thing. She's like, you don't want our law to go down this slippery slope of whoever could provide the most fun and the most amount of resources is the best family for a child. And she was like, of course this foster family can take this child to Disney every other weekend and like gets the best food, organic food and all this other stuff. But like, is the richest and like nicest family the best interest for a child? Because then a lot of us are at risk of losing our children, to the next, next richest family who can provide them more fun and more love and more excitement.
Yeah, that's good.
So I want to highlight that, and for sure that yes, this foster family is a beautiful family and they're providing a wonderful life for this child right now. But is that in the best interest of a child? Is that worth terminating a biological parent's rights and cutting that child off from that parent forever just so that this child can have like a nicer life? Because what we know is poverty is not abuse in and of itself. Like a parent not being able to afford to take their child to Disney and maybe only being able to afford them McDonald's instead of like a Whole Foods rotisserie dinner, like, is not abuse. So I don't know. I don't know where I would go with that, but it's so good.
Parents have to understand reunification is always the goal. Family law is a little different because the best solution to that would be mom and dad don't get divorced and they live in the same home and they raise the kid. But the standard for divorce is irretrievably broken, and that's the magic words, and you don't have to work on your marriage, and we can't force them to not get divorced.
Right.
So we don't have that option. But then second best goal is that the kid spends equal time with mom and dad, that they're both involved in decision making, they're both involved, in their sports activities, and that they're both providing financially. So we are always trying to work towards that goal. So in dependency, that's why you see the judges saying, let's give him one more chance. Maybe this is the time that he finally gets it, and that, he finally understands that if he doesn't do this, then his rights are going to get terminated. Because, when you terminate a parent's rights, that child forever is going to know about that. And they're always going to know. And I mean, even if they're a baby, I mean, at some point there may be that conversation, why are you not my real dad, or where's my real dad? So, you always have to think about that. Because again, the ultimate goal is reunification. And the best situation in a dependency case is that mom and dad do the right thing, and that they turn their life around and, end up raising their kid. And
so you're hoping as a judge that the foster family has that same presumption as well, right? You're talking about like the goal of foster care is reunification. As foster families, we're taught that when we go through our licensing and go through our training. Like that is the ultimate goal. Like that is the prize at the end, if you will, is see a family reunited and reconciliation happen and change lives happen, right? So we talked about a couple episodes ago about your standing as a foster family in regards to a biological family. Like I would encourage all foster parents who listen to this to not walk into a courtroom thinking that foster parents are the enemies, but also at the same time wanting to provide protection and safety for the children in their home. But have the mindset of how beautiful would it be if these parents got their act together and this family could live happily ever after this, right? Whatever that looks like. So have that same presumption of like, we want to see reunification happen in this case. We want to see that happen. But I think that there is an emotional side of foster parenting that pulls you into the nitty gritty of how could you do this to a child? How could you live life like this? Why aren't you doing what you're supposed to be doing? If it was my kid, I would be doing this. Like, how can you not do this for your own child? And it takes a lot to get to the place of being pro biological family and parenting.
Yeah. And that it's, the old saying, it takes a village to raise a child, right? And it takes, in dependency, even in family law, it's a team effort. That's why even in family law, sometimes we pull a guardian ad litem in, to help. It's a kind of a team effort. And I think as a foster parent, you have to understand you're part of that team. You don't get the final say,
right?
You're not going to get to just have your way and how you want this to end. But if they can kind of have that mindset, and I know it sounds bad, but you're a caretaker temporarily, and if you can help foster that kid in your home in the meantime, with the hope that he can be returned to mom and dad and be part of the team and understand that, then I think that would help. It all goes back to their expectations. And the other struggle I see, and we haven't done the fostering yet, maybe, but
he said, yeah, but, you hear that?
Well,
but you as a foster parent go through licensing, like you have a background check. That doesn't happen when you become a mom or dad.
Right.
Anybody can have a child. So, you're where you're at as a foster parent because you've been doing good and you love children and you have a job and you have a home and, so I think it would be a struggle, and I see the perspective of a foster parent going, struggling to understand because you've never been in that situation.
Yeah.
Like you haven't abused a child or you haven't neglected a child. Otherwise you wouldn't be a foster parent.
Right.
Although
hopefully
seen some, seen some cases there, but that's a different story.
Right.
But,
different podcast.
But again, it's expectations,
right?
Understanding your role and, but again, with the goal in mind of getting this kid back to mom or dad or both.
Okay, but we also need to know, like, when a biological parent comes in just lying through their teeth, do judges have a BS radar to understand that that's what's happening, even if you aren't like, and like, I just want to believe that judges have good poker faces, but like they leave the bench and they're like, I totally knew that parent was lying.
Yeah, absolutely.
Okay.
And sometimes we just can't say it.
Right.
We can't just be
neutral.
Outright and just,
Right.
I mean, we have to remain neutral. But yeah, I mean, credibility is always huge. I mean, in any legal case, credibility, any witness that takes a stand or anything, credibility is always number one. So yeah, I mean, you can see when parents are, lying or trying to pull the wool over their eyes. And, that's why going back to the team effort, that's where the foster families can kind of, give that information through the right channels to say, no, mom didn't show up for the doctor's appointment or mom didn't, show up for this visitation, and hopefully you have a good case manager that's documenting everything, because I've heard horror stories there where they're essentially covering for the parent. But that's why it goes back to, like, I love your idea of the, detailing notes and logs and of everything, because more information, the better. Right. And I go back to, like I said, it sounds awful because we get people come in all the time, don't you see the police report? No, we don't have access to that kind of stuff. Like we start kind of with a blank slate. So the more information that can be provided, the better.
So judges do appreciate kind of like being inundated with that type of information, because I've talked to a lot of foster parents that are like, well, I don't want to be overbearing. I don't want to overstep. Like I just let the case manager do it. And they don't want a judge to be upset with them for maybe doing too much. So is that a thing, or do judges appreciate information?
No, I mean, the more information, the better. I mean, because like I said, there's things that I want to know and I just can't pull it out of people, or, and that's, again, going back to like guardian ad litem. I'm a huge fan of that because they are an investigator. They can go and speak with the child. They can go and speak with a therapist. There's a lot of things that they can do as this investigator looking out for the child, to try to get information. But that's a great funnel for a foster family to get that information to them. But yeah, I don't think they should ever feel like they're being overbearing or being too detailed, because there's really not so a thing as too much information in a case, especially when it comes to children.
Yeah,
that's good.
Talking about guardian ad litem for a second. I'm not sure that everybody who will watch this knows exactly what that is, but it's a way to get involved in the child welfare system. We have people who, we talk to all the time, like, I don't know if I could open up my home. I don't know if I could, have kids in my place. I'm old, or I just don't have the resources, or I don't have the room or space, whatever. But there are so many different ways to get involved in the foster care world. And guardian ad litem is one of them. Can you just give an overview of what that is?
Yeah, well, every state looks a little different with this position, but in Florida specifically, it's a volunteer position. It's called guardian ad litem, and it's an volunteer individual that is trained to look out for just the best interests of this child and advocate for them in court. So, I mean, you've got case managers that are looking at everybody involved. They're trying to work the parents through a case plan. You've got judges that are trying to make decisions, looking at all the information. But a guardian ad litem is just focused on that child and being that child's voice in the court system.
Wow, what an important position.
And on top of that, by statute, they have a lot of authority to do things. Like they can talk to a therapist. They can go and interview the child. And then they can provide reports to the court, and the parties sign off saying that, they're allowing, there's no objection to this, like especially in family law. If they agree to the appointment of the guardian ad litem, they're agreeing that the guardian ad litem can come in and testify to hearsay that the child told them.
Wow, that's
things
huge.
Like that. They can testify to things that they gathered from a therapist or, teachers at school or foster families. So that's a great tool.
I'm so thankful that exists.
Yeah, I know my experience is that judges take the word of guardian ad litems pretty seriously.
Oh yeah. I mean, they submit reports, they come in and testify, and it bears a lot of weight, especially if you have one that's been doing it for a while and you trust. And a lot of them are attorneys. Attorneys sometimes get involved, which is different from an attorney ad litem, but a lot of attorneys will get involved in the guardian ad litem program. So they'll have a family law background, or they'll be familiar, and so that's really beneficial.
Oh yeah.
So
yeah,
that's great. I have one more question. I don't know if do you have any more questions?
Go for it.
I have one more question. You talked earlier about how you've done a couple of adoptions. Have you?
I haven't done any yet, but we deal with like the real simple, like a family, a parent, or like a grandparent adoption or things like that.
Gotcha. Okay. Well, I was gonna say, what, like, in that setting, in that environment, what is your thought process in that? Like, obviously you're not dealing with a foster family or an adoptive family outside taking custody of a child, but you're a judge and you're providing safety, security, a future home for a child with a relative, right? Is that what you're saying?
Yeah, that's mainly the ones we deal with.
Yeah. So what is that hearing like for you personally as a judge, if you wouldn't mind? Is there emotion behind it? Is there just like you're just trying to...
I mean, those are some of the more joyous cases that we deal with. The adoption cases.
Why is that joyous?
Well, I mean, because for one, usually everybody's in agreement, and the ones that we deal with, they're separate from the dependency ones. But there's just a lot of joy in it because everybody's happy, everybody's in agreement, everybody's knowing that this is in the best interest of the child. So, anytime we can get agreements, and a lot of litigation, that's the best cases for us as judges. But not that there's not joy in the ones through dependency.
Yeah.
And again, going back to the foster family and their expectations, it's great if they are ready for that step, if there is a termination of rights and they're willing to step in. So I wouldn't discourage them from thinking forward, and kind of having that in mind that, hey, if this goes bad, can we step in? So I don't want to discourage people from that.
Right, but that can't be.
But
the
it
primary
can't be your
motivation.
primary motive. No,
Yeah.
absolutely not, because you'll get heartbroken.
Yep.
Every time when the child, which you shouldn't. I mean, because again, if we all go into the goal of reunification, that should be a good thing. But I know we always, in the back of our minds, we're skeptical, especially as judges. We have a lot of skepticism. I do, at least. So you're kind of always thinking, is it gonna go back to, and there's things in the law that where the families can step in and and help if things go south again. And that's another thing I think it'd be a great thing for people to understand, is that, there are ways, if a child is reunified and then things go back, to being bad, then, there's ways to step in, and then all that information becomes available to us as judges. So back to like your statement, about second, third, fourth chances, like if you see a case where, you put this plan in place and you give the child back and then it doesn't work, then, you understand, now you can kind of dig in a little bit better, and try to, maybe go towards the termination.
Yeah.
So,
yeah. Big takeaway here that I want foster parents to understand is like, judges are not our enemies, right?
No,
like
not
judges
at all.
don't,
just regular
judges
people.
don't hate, I asked a foster mom, I said, hey, she's struggling right now. I said, hey, we're doing an interview with a judge. What do you want me to ask him? And she said, ask him, why do you hate foster parents?
No,
So
listen, we don't always like our decisions either. Like you shouldn't, as a judge, you shouldn't always love your decisions that you make, because, sometimes you're just following the law. Sometimes you're doing what the law requires you to do. And you may not agree with it. You may, as a judge, you might not really think, this is really going to work out in the long run, but you have to follow the law.
That's
you have to
so
follow
interesting.
the recommendations of the people. And if you have, somebody that's saying, it's in the best interest and this child needs to be reunified, then, unless you have something to disagree, you can't just say, well, too bad.
Just because you don't feel like it.
You have to make findings, and you have to follow all the factors. And so, again, we don't always love our decisions, and we don't always go back and, forget about cases or jump up and down and cheer. Sometimes we do our ruling and we just pray and hope for the best,
Wow.
That's good.
So,
That's a good word.
Yeah.
Man, that's crazy. Well, thank you for being on today.
Yeah.
We
you
really
for having
appreciate
me.
you coming by and
Yeah.
hanging out with us. We're going to do another episode next week.
Yep.
I'm excited for that. But for this episode, this has been Matt
And Lainey.
and Judge Aaron Hubbard saying thank you for watching, like, and subscribe to our content. If you enjoy conversations like this, we will see you next time on the Unprofessional Parenting Podcast.